In the state of Michigan, when a defendant is charged with a criminal offense, they may be released before trial under what is known as a bond a conditional release, governed by Michigan Court Rule 6106. Under this rule, the court has the authority to impose specific conditions on a defendant's freedom, and a violation of any one of those conditions gives the court the power to immediately revoke that bond and return the defendant to custody. The case before us today involves Julie Bell, also referred to in court documents as Miss Fong Fan, who has been charged with resisting and obstructing a police officer and malicious destruction of property, specifically a commercial building belonging to her former romantic partner. Miss Bell had been granted pre-trial release. She had been given bond conditions by the court, and by the time of this hearing, she had violated those conditions not once, but repeatedly. This is the bond violation hearing before Judge Cedric Simpson. And what unfolds inside this courtroom will raise a fundamental question about what it means when a defendant is given a second chance and chooses not to take it seriously.
Calls case People State of Michigan versus Julie Papachel.
Your Honor, I appreciate the court's accommodation. I had an opportunity to speak with Ms. Fong Fan. I discussed bond violations that have come to the court's attention since Ms. Fong Fan's last appearance before the court. Ms. Fong Fan.
Now that, as well as the continued lie.
Of course, Your Honor. And Ms. Fong Fan is going to apologize to the court. She's going to admit that what the court has been made aware of, her participation on a video podcast.
Okay, let's just get it all right, Mr. Warren. Here's the stupidity of this individual. I lock her in jail because she was lying to me and violating her conditions. One of her first calls from the jail is to a podcast. Am I right?
That's correct, Your Honor.
But then gets here and runs a ruse that she's really making the calls regarding her two children. Then, so not only does that then go on social media, there's then another one on social media shortly after when she was arraigned, where she was violating her bond condition at that time. I've yet to figure out why she doesn't have a medical marijuana card if that's what she wants to do. But she doesn't, and then just continues to use. Lied to community corrections, then lied to me. So she gets put in, then makes within that week at least 41 calls that we could see, but there were actually additional ones. Then can't wait a day after being released. And violates my order again.
And Your Honor, that is my understanding of where we are today in its entirety. And Ms. Fong Fan admits to all of those things. She did go into custody. She placed upwards of 120 to 130 phone calls, one of which was to a podcast. And I think that demonstrates to the court that her statements that she learned her lesson in custody, it may hinder that because Ms. Fong Fan was laughing, joking on a podcast.
Oh, yeah, she was. She thought it was all a game.
Of course.
And guess what? You can think it's a game. It's a game with me that you will never win.
What the judge has just described raises an important legal question. What exactly is a defendant permitted to do while in custody on a bond violation hold? Under Michigan law, a defendant in pretrial custody retains certain constitutional rights, including the right to communicate with family and legal counsel. Jails typically permit phone calls for this purpose. However, those calls are monitored, recorded, and subject to review by the court. When Miss Bell placed a call to a podcast laughing and joking about her situation, that recorded call became evidence. Evidence that directly contradicted her attorney's argument that she had learned her lesson and taken the matter seriously. Her defense attorney has now acknowledged to the court that Miss Bell made between 120 and 130 phone calls during her time in custody, and critically, he has also admitted on the record that the story Miss Bell previously told the court about time-released sea cookies was not true. Under Michigan law, a defendant on pretrial release who provides false information to the court or to their own attorney for the purpose of misleading the court may face consequences beyond the bond violation itself. Dishonesty before the court is not simply a personal failing, it is conduct that directly affects the court's ability to make informed decisions about a defendant's liberty. The judge has now heard two separate attorneys describe two separate sets of lies, and he is about to hear directly from Miss Bell herself.
Understand.
Ever. No, I don't think you do.
Can't speak.
No. Your Honor, that was the first week she was in custody. The following week, she lost phone privileges. She was released from custody, at which point she came before the court, apologized for what happened leading up to that.
Lied to Mr. Feaster, so Mr. Feaster would lie to the court.
Your Honor, I think Ms. Fong Fan understands that pretrial release is a matter of grace, and that for her to remain on pretrial release, she has to demonstrate to the court that she is going to comply with her bond conditions. She has had a turbulent journey on her bond so far. She's had several violations. There are renewed violations. She admits to all of those. She would ask the court to
including that the THC cookies, the time-released THC cookies, was a lie.
Ms. Fong Fan understands that that story is not feasible, that when you inspect the claim that was made at her first probable cause conference, that it doesn't make any sense. And she'll admit that today to the court, that a number of things she said leading up to this have not made sense and have turned out to be false. And when a person, anyone puts himself in that position, you have to tell lies and lies and lies to kind of undo what you've done so far. I think Ms. Fong Fan wants to ask the court for a clean start, to come clean as to...
I thought we did that the last time. This is almost the same spiel I was getting last time, right before she got out and on film dragged.
Right.
God only knows why you'd be mixing anything with Red Bull, but what the heck.
Understood, Your Honor. And she did drink. There's a video of her doing it.
Oh, yeah, there is.
And what she's going to ask the court to consider is continuing her bond, upwards modification, that she be placed on a other to monitor alcohol use, that she submit to ETG testing to monitor her alcohol use, and that she cease using social media while this case is pending. Ms. Fong Fan is serious about resolving this matter. She's serious about taking care of her two children. Her daughters, Maddie and Ayana, have upcoming birthdays on the 28th of March and on the 2nd of April. I know
so it'd be horrible if she's in jail on their birthday.
It would, Your Honor.
But it doesn't seem to me that she was really caring about them all this time anyway. No, she would have never put herself in the jeopardy that she's in right now.
Of course, Your Honor. I know her children are her primary concern more than anything else, that she's asking the court in a final act of grace to permit her to remain out of custody, continue her bond with those modifications, comply. And Ms. Fong Fan can address the court and come clean about any violations of bond leading up to today.
Go ahead. What does she want to tell me? Mr. Allen.
I just wanted to apologize for starting off with a bad start with you. I hope that start over. I did my time for bond violation for 2 weeks. I messed up the first week the second week you revoked my phone privileges. I learned my lesson. I had some time to think about what I've done, and when I figured it out, I did have that cup of alcohol on the podcast. I truly thought that it was just no smoking weed, but I didn't know alcohol was a problem. But now I know. I do not have an alcohol problem. I was just drinking.
How am I supposed to know that?
You don't.
You
don't.
That now you've learned your lesson.
I know.
Tell me how I should know that.
I know that anything that I say, you probably won't believe because we started off badly.
Oh, and you lied.
Yes, Your Honor.
It's not just little lies, big lies. Every step you've gone, you've been lying. So tell me why I should believe you now.
I don't have a reason or any excuse to argue with that. I understand.
Your Honor, I think Ms. Fong Fan knows it's not about what she says, it's about what she does. And what she's done leading up to this has not instilled confidence in the court that she's going to comply. We're asking the court to give her an opportunity to demonstrate that she's going to comply with the court's orders and perhaps present herself as a candidate for at the conclusion of this case.
I know you're upset at me.
Oh, I'm not upset because I definitely get to go home today. So I'm not really upset. Go ahead. What did you want to say? You just think this is all a game. That's what your problem is. You do. You think this is all a game.
I can say definitely I didn't take it seriously the first week. The second week after I stayed in, I had a lot of time to think.
About what?
About, my actions before, during, and now after the fact, even having a drink. And I guess if you want to put me back in jail, I deserve it.
Yeah, you do. You have a CPL?
Yes.
Lost it. You know why? Because you
Not
can't
really.
be smoking and have a CPL. That's probably another form you lied on. How bad do you want to make this get, young lady?
Can you say that again?
How bad do you want to make this get? Because if you want to take this thing and make it the worst experience you ever had in your life, I'll be more than happy to indulge you.
I don't.
So whose rules are we going to play by?
Yours, Your Honor.
Absolutely. Problem is, I don't know that you know how to do the right thing. I think somebody that lies as much as you do about everything, it seems, and just kind of does what you want to do. Because you've probably been doing this your whole life. And that's why you can't change.
May I have the opportunity to say a couple of things?
Oh, absolutely. I'm sorry, Ms. Hughes.
I appreciate it, Your Honor. Your Honor said something very interesting. You've probably always been this way, so that's why it's so hard to change. This behavior is exactly what this case is about. She's charged with R&O. She's charged with malicious destruction of a building. She went to her ex-boyfriend's business and kicked his front door of his business. The police arrived and she immediately started lying to the police that she had just got there, that she hadn't kicked in the front door, that she didn't know what was going on. The police wanted to conduct their investigation, so they asked her to just wait in her car. That's all they asked her to do. And can you just wait in your car? And she took this as an opportunity to defy them rather than just listen to them. She told them, I'm not doing nothing. I don't need to go to my car. They asked her again, please go to your car. She decided to cut off Officer Cunningham, not allowing him to speak. He said, well, you can either wait in your car or you can wait in my car. She said, take me to jail, fuck it. Yes, go ahead, take me to jail. So I instructed her to put her hands behind her back, is what Officer Cunningham's report says. She then began to verbally and physically defy Officer Cunningham to the point that Officer Baldwin, another Ann Arbor officer, had to get involved. When Officer Baldwin approached, the defendant turned to Officer Baldwin and pulled her left hand away and said, don't make me swing on you, to a police officer. So yes, this is what she does. She lies and she wants to play by her own rules. So by continuously violating Your Honor's orders, this is just a game at this point. Your Honor, I'm asking that you remand her. I'm asking that her bond be revoked and that no bond be set at this time.
The prosecutor has just placed the underlying charges into full context and what she described as legally significant beyond the bond hearing itself. Ms. Bell is charged with resisting and obstructing a police officer under Michigan Compiled Law Section 750.81d. Under this statute, a person who assaults, batters, wounds, resists, obstructs, opposes, or endangers a police officer performing their duties may be charged with a felony offense potentially carrying up to 2 years in prison. She is also charged with malicious destruction of property under MCL 750.377a for allegedly kicking in the front door of her former partner's business. What makes the prosecutor's account legally important is the pattern it establishes. Ms. Bell allegedly lied to police the moment they arrived at the scene. She refused a lawful and reasonable request to wait in her vehicle during an active investigation. She physically resisted arrest. And she threatened to strike a law enforcement officer. Now, inside this courtroom, that same pattern has continued lies to her attorney, lies to the court, a podcast from jail, and a bond violation within 24 hours of release. The prosecutor is now asking the court to remand Ms. Bell with no bond. Under Michigan Court Rule 6.106F, the court may deny bond entirely if it finds that the defendant poses a risk to public safety, is unlikely to appear for trial, or has demonstrated that no conditions of release will ensure compliance with court orders. Whether the judge agrees is what we are about to find out.
Mr. Warren Green.
Thank you, Your Honor. Ms. Fong Fan, as the court knows, is a mother. She was previously employed at the University of Michigan, stocking shelves. She lost that job when she was remanded to custody, and I know that she is seeking reemployment. Ms. Fong Fan fully understands that the consequences of her actions.
Does she, though? Does she? I mean, I don't know anything about what was necessarily alleged in the case other than the charges, right? And then to hear that recitation of what this case is about and then look at this defendant's behavior, does she really? And I don't know why these kids keep coming up as some shield because it appears to me everything she's doing is has nothing to do with them. She's just running her world. Go ahead. I'm sorry I interrupted you.
Your Honor, Ms. Fong Fan has faithfully attended all of her court hearings. I believe that with added conditions of alcohol monitoring, that the court's concerns about her drink be suppressed. I know it's difficult to address the court's concerns about Ms. Fong Fan's dishonesty. I believe she's come before you today and been honest about her past conduct and the conduct even after she was released from custody before court today. I'm asking the court to consider continuing her bond with those added conditions, as Fong Fan will test today and tells me she will test clean.
Anything else?
Nothing further, Your Honor.
Not showing anything else.
Well, I can speak. I just wanted to say sorry. I've made some mistakes that day when that happened. I didn't necessarily just kick in the door. It was more to it inside. And it just escalated. I was upset. I didn't mean to harm or disrespect Officer Cunningham. I didn't mean it for it to escalate that way. And I hope that I can apologize and make it right. I'm trying to. Since this has happened, it's my life is in shambles. I'm trying to figure it out. Being in jail I get to sit and think about my actions and, actually learn from them. But being in there, I can't get things done. Like I have to figure out getting another job, paying bills. Not that you care, but I'm trying. I'm trying to make it every court date. I quit smoking weed. If I can be placed on an alcohol tether or have to drop for, urine. I ask, can you still give me another chance?
And you said something very interesting. You said, I don't care. Not that I care.
Just now?
Yeah, that's a funny thing. Because actually, about everybody that comes before this court, I care. I do. Maybe sometimes to my detriment. I do care. I don't understand your stupidity. I just don't get it. And you're asking me to give you another chance. You got the first chance when you were first out. Put you in. I bring you back. And you put me in a position where I can't give you another chance. So then you're in there another week. told me that day, you and Mr. Feaster, you had learned everything and you were going to be able to conduct yourself by the court rules and everything else. You don't at 24 hours, you don't make it 24 hours. And you all think you just think that all of this is a joke. Don't get to just have your way because you want to have your way. Always. There's a bigger bully. But if you think I am going to tolerate this, wrong judge.
I know.
I do not like sending people to jail, but I'm going to do my job. And if you can't cooperate, if you can't just do the simple things that are asked, none of this stuff is hard. None of it. But if you've got to pretend to all these folks that this doesn't bother you and you're just too cool for any of this, you're just going to make it, well, okay, so be it. You can sit up there and be everybody's hero. So, Mr. Warren Green, here's what I'm going to do. I'm going to adjourn her preliminary examination. I'm adjourning her preliminary examination April 23rd, 2024 at 9. That is before me. It will give you the opportunity to certainly motion before this court this defendant's release. But for today, she's going. Defendant's bond is hereby revoked pending a motion.
Miss
hearing.
Bell's bond is hereby revoked. She is remanded to custody. Her preliminary examination has been adjourned to April 23rd, 2024. And upon any future release, she will be placed on an alcohol scram tether, a continuous transdermal alcohol monitoring device worn on the ankle that detects alcohol consumption through perspiration, 24 hours a day. The judge declined to set no bond entirely, leaving the door open for a motion hearing before him on a Wednesday date, giving defense counsel one final opportunity to argue for her release under modified conditions. But what this ruling illustrates is something broader than one defendant's bond status. Under Michigan law, pre-trial release is not a right. It is a privilege extended by the court under Michigan Court Rule 6.106, and that privilege comes with conditions. When a defendant violates those conditions, lies to the court, makes 130 phone calls from jail, including a podcast appearance, and violates her bond again within 24 hours of release, the court has not only the authority, but the obligation to respond. Judge Simpson noted that he does not enjoy sending people to jail. But he also made clear that the courtroom is not a place where personal rules override court orders. There is, as he put it, always a bigger bully. Miss Bell will now face the remainder of her pretrial period from inside a jail cell, and the underlying charges of resisting and obstructing a police officer and malicious destruction of property still await her
Revoked
at
pending
trial.
motion hearing. If defendant is released from jail, she will go on an alcohol scram test. Thank you.
Thank you, Your Honor.
They just took somebody back, so I can't bring that one out. Mr. Warren Green, if you have that, you can set that on a Wednesday for any type of motion hearing on a Wednesday.
I will file it.
You do that. It's on a Wednesday, so Miss Perrone and Miss no, Barroso's not going to help me. Miss Coons. Ms. Perrine, Ms. Coons can help you.
Thank you for watching Judge Talk Zone. If there is a case or courtroom moment you would like us to cover, let us know in the comments below. And don't forget to subscribe so you never miss a ruling.